Okay, good morning everybody and welcome to this licensing subcommittee in respect of a application for a new premises licence in respect of the Live Lounge 18 Ipswich Street, Stowmarket. The applicant is ACDN Lounges Limited. I'm Nigel Deleu, I'm the legal advisor to the subcommittee. I'll quickly explain how the procedure works. We have a few housekeeping and a few formalities to go through. It is a formal subcommittee, so there is an agenda to follow. But once we get into the hearing, the application proper, there'll be a fairly simple procedure. There'll be a report from the licensing officer to outline the application and some of the issues involved. There'll be an opportunity to ask questions through the chair if there are any queries or any clarification required on that. Then we will follow with the application. The applicant will make a representation to the members in support of the application, and again there will be an opportunity for questions to be asked simply for clarification. Once all those questions have been asked and the subcommittee is happy to move on, those that have made representations will also have an opportunity to make those representations verbally. They will be in relation to the written representations they have already made. Obviously you can expand on those and fill in any gaps that you feel need addressing for that. And again, there'll be an opportunity for questions, and then there'll be an opportunity for all parties to sum up before the subcommittee go into a private session to determine the application, and that decision will be announced as soon as possible this morning. So I shall move on to the first item on the agenda, and that is the election of chair. Do I have a nomination for chair, please? And that's seconded. Okay, Councillor Wiltshire is the chair for the subcommittee, and I'll hand over to you, Chair.
Technology. Welcome everybody to the meeting of the Licensing Subcommittee. I'm Councillor Nicky Wiltshire and I'm Vice Chair of the Licensing and Regulatory Committee, and I'll be chairing the meeting today. The meeting will be broadcast live to the internet and will be capable of repeated viewing. The whole of the meeting will be recorded except where there are confidential and exempt items. If any members of the public attending the meeting objects to being filmed, please advise us immediately and we will ensure that they are not included in the filming. Members of the public and the press may record, film and photograph or broadcast this meeting when the public and press are not lawfully excluded. If you're intending to do so, please could you inform the committee clerk. You'll be invited to speak and ask questions by the chair. Please do not interrupt others speakers. May I please request that mobile phones are on silent or switched off and that your laptops are switched to silent. If you hear the fire alarm, please leave the building immediately via the fire exit and make your way to the assembly point at Ipswich Town Football Ground. Can I ask if there's been any apologies of absence?
None received, Chair.
I ask the councillors if there are any declarations of interest.
None.
We'll do some introductions. As I said, my name's Councillor Nicky Wiltshire and I'm the councillor for Rattleston Ward. And my colleagues?
I'm Councillor Jen Offra and I represent Elmswell and Woolpit.
Yeah, and I'm Anders Linder, District Councillor for Laxfield and Stradbroke.
And our legal advisor?
Nigel Deleu.
And our licensing officers?
Licensing Officer Kerry Chandler.
Kay Sanders, Licensing Officer.
And our governance officers?
Karen Sayer, Governance Officer.
And can I ask the applicant to introduce themselves?
Yes, good morning. I'm David Dadds. I'm counsel for the applicant. The applicant is a company, ACDN Lounges Limited, and I have with me, speaker on.
Nicole Watkins.
Thank you. Can I ask to confirm that you confirm receipt of procedure report and copies of relevant notice?
I have, and may I ask when it's appropriate that Councillors, just to confirm they've not been lobbied in relation to the application, please.
Absolutely. Can I ask the councillors to confirm?
Yeah, I can confirm no lobbying whatsoever.
I confirm the same.
Oops. Can I ask other persons to introduce themselves if they would like to appoint a spokesman to put their views forward?
Good morning. My name is Tracy Smith and I'm a Director of Maltings Entertainment and we have a few concerns that I'd like to discuss.
A question to the licensing officer. Have there been any requests from the parties permission to call witnesses?
None received, Chair.
Have the parties indicated they wish to present documentary or other material?
None received, Chair.
Can I ask you to estimate time required to present the case and ask questions of other parties of the hearing?
About 2 hours, no, about 10 minutes.
That's 2 hours and 10 minutes.
We'll order lunch. And could I ask other parties how long that they think that we require to present their case and questions to the applicant?
2 to 5 minutes.
Lovely, thank you. So I'll ask the licensing officer to present their report MLSC 251 and to summarise the matter under condition, please.
Thank you, Chair. The hearing is to determine an application for the grant of a new premises licence made under Section 17 of the Licensing Act 2003. A copy of the application was received on the 13th of March 2025. This application is attached as Appendix A to this report. Full details of the original proposed activities and timings are contained within the application form attached as Appendix A, alongside the steps proposed by the applicant in the operating schedule Part M. The amended plan, as requested by Mid-Suffolk District Council Environmental Protection Team, detailing the areas to be licensed, is attached to this report as Appendix B. Further conditions have been added to the application following mediation between the applicant, police and Mid-Suffolk District Council Environmental Protection Team, attached to this report as Appendix C. Following further mediation between the police and Mid-Suffolk District Council Environmental Protection Team and the applicant, see attached Appendix D for amended timings. A plan detailing the location of the premise and objectors' addresses is attached to this report as Appendix E. A hearing is necessary to determine the application following receipt of representations which have not been withdrawn. The subcommittee will be aware that its consideration is confined to promotion of the 4 licensing objectives, and the need or commercial demand for licensed premises are not considerations for the licensing authority when discharging its licensing functions, as outlined by the Secretary of State at paragraph 14.19 of the guidance issued under Section 182 of the Licensing Act 2003. The subcommittee must, having regard to the representations made, take such of the steps, if any, as it considers appropriate for the promotion of the licensing objectives. To grant the licence subject to conditions which are consistent with the operating schedule accompanying the application, modified to such extent as the authority considers appropriate for promotion of the licensing objectives, and subject to any mandatory conditions which might be included in the licence. Or to exclude from the scope of the licence any of the licensable activities to which the application relates, to refuse to specify a person in the licence as premises supervisor, or to reject the application. For these purposes, conditions of the licence are modified if any of them are altered or omitted or any new condition is added. Any party aggrieved by the decision taken by the licensing authority in respect of this application has a statutory right of appeal to the Magistrates' Court. This concludes my report.
Thank you. I will now ask the applicant if they've got any questions of the licensing officer.
Yes, please. Could I ask, police officer, has there been any attempt or assistance to facilitate some mediation between those that remain objectors and the premises, or the applicant, sorry.
Yes, there has. We went back to the representations and advised that obviously the application had been changed completely from the original, and asked whether they would be willing to remove their representations. One did, so one did remove and was happy with the new hours, etc. put forward, but the other three still remained and were not willing to mediate.
And can I ask if other parties have got any questions of the licensing officer?
I'm not 100% sure that I've actually seen the revised timing, so that may have an impact on our view, but he has he? Okay, then no. Thank you.
And have any of the subcommittee got any questions for the licensing officer?
Yeah, I'd just like to ask about Appendix D. From my reading, non-standard days aren't covered there, so I think that needs some clarification. Thank you.
There is no change to those. So the hours on the Appendix D are the hours that were submitted, but there was no change to the non-standard timings.
It remains as per the application,
Okay.
the non-standard timings,
Yeah. So the New Year's Eve, St George's Day, etc., will go to,
as per the application.
yeah, as per the application.
Thank you. So now I will ask the applicant to present their case to the subcommittee, please.
Yes, thank you. I will try to keep within the 10 minutes. In fact, I hope you will forgive me. I'm sort of going to cover some of the basics of the Licensing Act, and I know you already know it, but it would be wrong of me not to at least set out where we are coming from. So please forgive me if I'm just repeating stuff that you already know. Well, you will know. Obviously, each application is based on its own merits. An application is advertised in the normal way, 28 days. And if there are no objections, it must be granted. The reason why we're here this morning is because there are 3 representations. And those 3 representations have to be heard here at the committee, and you'll be the decider of those facts. But that's the only reason. So therefore, the burden of showing that in effect, the licensing objectives would be undermined are those representations. Because if it wasn't for those representations, it must be granted. So it really falls heavily on those who make representations to show why they believe that this application, in its form, undermines the licensing objectives. So very basic principles. You will also know that under the statutory guidance there's roles for responsible authorities, and that's covered in Chapter 9 of the statutory guidance. And in principle, each responsible authority, so for example the police and environmental health and the licensing authority, all are experts in their own field and right. So for example, on crime and disorder, the police would be your main source of advice. And that's the statutory guidance at 2.1 of the statutory guidance, that's the paragraph. So on noise, it will be the environmental health officer, and in relation to your licensing policy, it would normally be your licensing authority as a responsible authority. I can say that after much discourse and discussion, none of those responsible authorities object to this application. So what that means, put simply, is that they are satisfied that the licensing objectives will be met, and that should play very heavily on your minds this morning. And the principal case for that is called Daniel Thwaite, and that established the principle that even though they're not here, you still have to have regard that they haven't made representations, and in fact they have, but we've come to an agreement with a schedule of conditions. So, putting it fairly simply, I have to, in effect, address you on the representations are made, and then it's for those who make representation to persuade you that not to grant or to do something else. Now, there are 3 representations, and I can say that they're all, in our opinion, trade objections, trade objectors. So Carla Halls is, I believe, the assistant manager and certainly a member of staff for the Royal Oak. And the other person, if you bear with me, technology, I said 10 minutes, but that's subject to me being able to use technology. Yes, and James Farrington is the manager of the Royal Oak. We have, before we made the application, visited a number of premises, including the Royal Oak, to tell them what our intentions were, to discuss it with them. We've offered mediation, that's been refused. The council's also tried to assist, refused. They don't make it clear in their letters that they are manager or members of staff, and that there's a potential for a conflict, that perhaps one should be candid and open. Their representations don't withstand the scrutiny, I would say. They're trade objectors. And even more, there's a case called East Gwent, and it's a High Court decision, which is trite law, that the makers of a statement, if they're not present, then you will attach probably little or no weight to those statements, particularly if they're trade objectors. So, in other words, they're not here, we can't ask them questions, therefore what weight do you attach to the representation? In effect, little or no weight. That's a matter for you, weight. I'm not saying they're not relevant, but weight is a matter for you as the decider of fact. Then we're left with the representation by the company of Maltings Entertainment Limited, which I understand Tracy Smith is present today as a director of that company. Perhaps that will be clarified. But the representation is in Appendix F. This representation stands in its own right, and in my respectful opinion, nothing new can be added other than maybe amplified what's written, but nothing new today. You will see that they raise, in effect, principally 2 points. One, public nuisance on dispersal and the possibility of merging. I would say that the Environmental Health Office and the police service and the licensing authority are experts. They're aware of the times, don't raise any objection. As I say, I believe that this is a trade objector. In relation to public safety, I think they've misunderstood the Licensing Act objective. Public safety is about really the physical building. It can touch on some of the consumables potentially, but not normally. It's the physical building. So I think that's misunderstood. So there's no undermining of public safety. The building is appropriate. The fire service have been consulted, and the planning authority too. So in relation to their objections, 1, the starting position is a trade objection. 2, competition or the need for another premise is not relevant under the Act, and that there's no primary evidence or evidence here that would come to anywhere near where that you would be satisfied on the balance probability to do anything but to grant the application as we've amended. My representations are put very simply like that the licence should be granted. Your professional officers have looked at it. I know that your discretion is engaged, and I ask you, because you've read the papers, for me, I'm not going to go through it, you've read it. Unless you want me to clarify anything, I'm here to answer any questions. That is simply put, we ask the application be granted.
Thank you for that. I will now ask the members of the subcommittee, etc., about exactly that. Questions that we have for clarification, please. I was going to say, yeah. Councillor.
I wonder about a few things. How many guests are you expecting to harbour at any given time on these premises? That's my first question.
We're waiting for a number of steps to finalise the figure, but it will be approximately 200 to 250. But we are obviously going to seek to maximise capacity, but doesn't mean that we be at capacity. But I would remind councillors capacity is not a matter of the licensing authority. It's done under other legislation. So fire safety, under the fire safety order regulations 2010, will control that in relation to doors, furniture. There are a number of things that we want to clarify first, but there will be a risk assessment, there will be a safe occupancy level agreed, and that's how we will proceed.
Yeah, I wanted to ask about the space above the floor plan, and I don't know who owns that, but is there any access to that, and is that anticipated to be used if it's yourselves who own it?
Our lease will be for within the building, and as my instructions are that there's no intention to go up, and if there were, we would have to put that in within the plan.
So there is no access from this floor to the upstairs floor?
No.
Thank you.
I wonder how large will the cellar be, and what are the intended use of the cellar?
It would fall outside of the licensing area and plan. The cellar is the cellar, and it will be used for non-licensable activities, so therefore not relevant. So I've never been asked about the cellar before as a question in 20 years, and I don't know really how to answer it because it's not part of the licence. But maybe if you can tell me what you're thinking, why you think it's relevant, I will try to answer it, because I genuinely want to answer your question, but I don't think I really understand.
To be frank with you,
yes,
you don't have to answer any questions. You don't have to answer the question. I'm merely asking out of pure interest. And if you don't want to answer that question because you don't have to, feel free not to answer it. Thank you.
Councillor, it isn't that. It is that I understand my rights to be able to answer any question on behalf of the client, and obviously I would decline if I thought it was not appropriate. What I'm trying to do is clarify in a professional way that I don't really understand the question, how it's linked to the licensing application, licensing objectives. And as you said, it's a matter of interest. Okay, that might be of interest to you, and I'm quite happy to see if we can answer that for you, but it's not relevant to this application. And as I say, normally the cellar is drawn on the plan as an indication for the storage of consumables and other materials, but public are not permitted, no licensed activities occur in the cellar, and so I'm not being rude in any way. What I was trying to do is understand if there is anything there that I need to understand further from you. If it's just a matter of interest, I don't think I can help any further.
Thank you for that. I know that it will not be used by your patrons. That is fine. Thank you.
Can I ask, as I say, we talked about you're waiting for the fire assessments, etc., in order to get actual capacity numbers and about what's safe and what isn't, and this is all about public safety. So it's a question of how you're going to measure that footfall, and you've put in the application about Fridays and Saturday evenings, that's great, but it doesn't actually, for normal days and during the week, how are we going to make sure that those limits aren't exceeded? What measures are being put in place?
We would, once we receive the safety, the risk assessment with the numbers, we've got a good indication, but we'll wait, because ultimately the structure of the building is as it is, and no different to this room. I could probably do a rough calculation based on the fire exits, but what changes it, if this room didn't have the tables and chairs in, it would be greater than it otherwise would be. So I think what we would do is, obviously during, when we are at peak times, we'll have door supervisors counting in and out, and during the week there won't be peak, but in an event there will always be a duty manager ensuring that we're within safe capacity. I mean, I think it's fair to say that you can make an observation even by your own eye that if you're at half capacity, you're well under. If you're suddenly increasing, you've got to start counting.
I appreciate this has not been raised by any objectors, but I would just like to comment on, there's a reference in your general comment section to vulnerable adults, but this isn't addressed in any detail in terms of a commitment to that group of people in your objectives. And I would like to see a commitment to safeguarding of women and vulnerable adults under licensing objective public safety. Thank
yes,
you.
Well, I can answer that, and I'll answer any question you have regarding this application. The premises has signed up to a system called Licensing Connect. In fact, I helped write Licensing Connect, and within that system, it's a digital platform. It has the WAVE training, so the welfare and vulnerability and engagement training, and it has instruction. It's an online. Every member staff has to do the course. It talks about vulnerability, welfare, spiking, Ask Angela. In addition to the platform, it has a vulnerability book, so it has a register, so it can be kept as a if any matters arise, what you've done. It also has an instruction and a video that it's accessible all the times, and all members of the team will have that. So in place is a very robust structure for vulnerability, welfare and engagement, with not only does that mean that our staff are protected and looked after, members of the public and the wider community. So there is a robust system in place for training, supervision, reporting and review.
As I say, one of the objections or concerns is about noise nuisance, and we've got the timings, etc. I think for us it's more about the recorded music, because there is a small space at the rear of the premises which is included under the licence, which the Environmental Protection team has stated that there should be no more than 10 people outside, etc., to keep the noise reduction down. How are you going to be sort of measuring, monitoring? What are you putting in place to ensure that that doesn't sort of become a crowded hotspot?
Sorry, we'll have members of staff that will be supervised. We'll have the licensing conditions. Everyone will be trained. And it will be managed so that the condition will not be breached. And in relation to noise nuisance, we're confident, as well as your own officers, environmental health, that there won't be any public nuisance.
Yeah, could you just say a bit about how you're anticipating using that outside space? Because at the moment, I think you're talking about selling alcohol there as part of it as well, and providing entertainment. So I just wondered what that meant in reality. Thank you.
It will just be a place for consumption and for smoking, and it will be managed. And certainly, there's no bar out there or anything like that. So, and I think these types of spaces are normally quite encouraged because it's better than out on the high street. It can be managed and supervised. So it'll be under CCTV, under management supervision, and properly controlled.
Will it have seating? Are you anticipating people sitting out there and socialising, or is it just for smoking?
No. No, there won't be any seating. There's no intention to do that. So maybe higher shelves or tables so people can place a drink. But there will be appropriate signage about ensuring that people keep an eye on their drink and respect each other.
I was going to ask a question. Right.
With regards to the outside plan, can I just clarify that it is for sale of alcohol as well out there, as well as consumption, as per the plan? Please. Thank Thank you.
Yes, it does have it within that red plan, but as you can see where the bar is, and the idea is that people will just go out there and consume. But I think it's just practical to put a red line around the whole area rather than distinguishing it any differently.
Thank you.
As you stated, that in the environment plan, that patrons are not to use the outside immediately adjacent to the front of the venue for smoking or consuming alcohol. So what measures and assurances have you put in place to ensure that that agreement is met?
Well, we'll have staff and supervisors to make sure that occurs, and there won't be any re-emitting. So ultimately, if you go out that way, you're not coming back. So you need to go to the designated area. It's to be managed.
And is that going to be managed at all times or just on a Friday and Saturday?
No, it'll be managed at all times because we need to uphold the licensing objectives and conditions.
Yeah, I just have a question around the floor plan. Do you the space where you've got the kitchen and then you've got a closed area for the steps to the cellar, and you've also got the toilets? The doors are very I'm not sure where the door is for the toilet, so I guess that's one of the questions. It just seems a very small area. There'll be accompanied children going to the toilet, there'll be wheelchair users, there'll be people going out for smoking, members of staff checking on the outside potentially, and also the kitchen exit very close, and the cellar where people will be bringing stuff up and down. And I just want to make sure that there will be a clear freeway for children and for people in wheelchairs and overall safety. Thank you.
It has been appropriately designed and measured, and we can give you the assurance that those that do have access will have the appropriate access.
Anybody got any more questions that they wish to ask for the applicant? Any questions from you? No? If we've finished asking our questions of the applicant, I would now like to ask Smith, the representative, to present your case, please.
Chair, did you want to ask Ms Smith if she had any questions for the applicant?
I think she did, yes. She
Okay,
declined. Yes.
beg your pardon.
Okay, so quite simply, we don't believe that it's in the best interests of the residents of Stowmarket or the local emergency services to have two licensed entertainment venues, both closing their doors at 4 a.m. at weekends and over bank holidays. So dispersal of clients within the same time window, especially with the increased footfall, which we both hope will happen, could potentially cause bottlenecks and lead to disruption and disorderly behaviour. Safety of both our customers and staff is very important to us, and we want to avoid creating an unsafe environment for their homeward travel. And that's it. It's quite simple. It's just the timings.
Thank you. So I'd like to know if we've got questions for Smith, please.
Yes, I read the mentioning of bottlenecks, and as I don't live in Stowmarket myself, it's not quite clear to me how, where, and when they would occur. So please do tell us a bit more about that.
So Martin's Entertainment, which incorporates the Carbon nightclub, is located very close to the train station, whereas the venue for the Live Lounge is in the centre of town. So there'll be those that are coming from the Live Lounge potentially to the train station or the taxi rank, which will be walking past the Maltings Entertainment frontage. Or conversely, there could be patrons from Maltings Entertainment which are going to be walking home or walking into town for something to eat, maybe, you know, a late night kebab, for example, that will then be walking past the live lounge. And there is a space by the church. I say, if you don't know Stowmarket that well, it's quite difficult to explain it, but there is, you know, there might be people walking through the church, churchyards to access one another. There is just the potential for bottlenecks.
Yeah, thank you. I know what you mean, thinking about the church. Thank you.
Can you tell us your operating hours on non-standard days? I'm thinking of New Year's Eve, St George's Day, St Patrick's Day and bank holidays.
Closure at 4 a.m.
Does that include the bar? Or what time? When does the bar start?
The bar stops serving at 3:30.
3:30. Thank you.
So are there any more questions for Smith and the...
Could I just seek clarification? Is New Year's Eve, do you not have from New Year's Eve to the end of New Year's Day on your licence? Or are you restricted to 4 o'clock?
I would have to check. I'm not 100% aware, but I believe it is until 4 a.m. When we were in the previous premise in Riverside Entertainment, we had an extended licence. So maybe you're referring to that.
No further questions from the representation? So, we've had the case for the applicant, we've heard the representation against. I'm just wondering if there's any more, if there was any other witnesses or any more questions or summing up that anybody wishes to put to the committee, please.
Well, I'd certainly like to have a very brief closing, maybe only 2 minutes, but after the other parties, normally the applicant goes last.
So over to you, Mrs. Smith.
I have nothing further to add from my previous statement.
Has the licensing officer got any other questions?
Nothing further to add, Chair.
So very briefly, you'll see in your agenda pack at page 44 the location where the mill is and the little red dot pin where we are. The suggestion of a bottleneck or some form of bottleneck is we don't accept. The police service are fully aware of the application and hours, and in fact we have slightly more, and they've put it in line with the mill, so it's actually parity. We don't know their capacity at the mill, and it may be that they're busy or full, but given that they're the only premises, it may be that they are full at the moment. But when we open, we hope to take as many customers as we can from them, so they'll be not so full. Also, the other thing is that if they are concerned for their own customers and how they serve their customers, they always have the right, because obviously they've got to promote the licensing objectives. They could always close a bit earlier if they want to. Obviously they have to do their own risk assessments. So I would encourage them to, if they're so concerned about their own customers' safety, and that is important, that maybe they consider closing early. Certainly from our point of view, we have gone through due diligence, risk assessments, discussions with the police, licensing authority, environmental health, while consultation with the community, and we believe that this application promotes the licensing objectives, not only us, so does the responsible authorities. We ask it be granted.
Right, I'd like to thank everybody and say that hopefully you've all satisfied that you've had enough time to put forward your case and questions. And on the basis that the subcommittee considers that the public interest in excluding the public outweighs the public interest in its deliberation being held in public, it is resolved that under section 100A, subsequent 4 of the Local Government Act 1972, the public be excluded from the meeting on the ground that it involves the likely disclosure of exempt information, as defined in Part 1 of Section 12 of the Act on the grounds set out in Regulation 14.2 of the Licensing Act 2003, hearing Regulations 2005. So I'll ask to pause the live streaming.
It needs to be seconded.
Oh, sorry, that's motion.
I'm happy to second that.
Is there? You agree that we will have deliberations? thanks everybody for coming back. I shall hand you over to Nigel with our deliberations.
Thank you, Chair. Thank you, everybody, for waiting. The subcommittee have considered this matter very carefully. They've considered the written representations and the verbal representations today. Firstly, they would like to state that they know that two of the objectors have not attended the subcommittee, and they would have liked to have heard from them and have the opportunity to ask questions. Therefore, they've given very limited weight to those representations and feel that what is written is not sufficient to impinge on any of the licensing objectives to warrant any refusal or amendment in respect of those. The subcommittee is grateful for Mrs Smith to attend to give her representations, and they have considered them very carefully. However, they feel that the concerns raised are rather speculative and limited in any sort of resultant antisocial behaviour or bottlenecks forming. And in this respect, they've considered the fact that there are only two premises that potentially close at the same time. There is a distance between them, and also that there are taxi ranks serving both areas. So they feel that there is a very limited opportunity for that kind of disturbance to occur. The subcommittee also acknowledged that the applicant has submitted a fairly comprehensive operating schedule and has also agreed to further conditions and amended timings as requested by the police and the Environmental Protection Service. Therefore, the application is granted, subject to the inclusion of the modifications included in Appendices C and D. The applicant and all parties who have made a representation have a right of appeal to the Magistrates' Court if they are aggrieved by the decision or the imposition of any conditions to the licence. Such appeal should be made within 21 days in writing to the Magistrates' Court from the date of receipt of written notification of this decision. Thank you, Chair.
Just reminds me to thank everybody for their attendance today and the hard work that's been put in, and wish you all the best, and let's hope that you maintain and uphold regulations that have been set down. Thank you.